What if I told you that the people who never lose everything in a financial collapse aren't the richest people in the room? They're not hedge fund managers. They're not billionaires with offshore accounts. They're teachers, nurses, small business owners, people exactly like you. And they all did 5 specific things before the crash hit. Here's what nobody tells you about financial crises. They don't announce themselves. There's no alarm. No government official goes on television and says, "Hey, you've got 90 days to protect yourself." What actually happens? You wake up one morning and the headlines are already written. The damage is already done. And the people who didn't prepare? They spend the next 5 years clawing back to zero. We've seen it in 2008. We saw echoes of it in 2020. And right now, the warning signs that preceded both of those moments are quietly showing up again. Debt levels, bank stress indicators, consumer credit defaults creeping upward. I'm not here to scare you. I'm here to do what the financial system was never designed to do. Actually tell you what's coming and give you the tools to survive it. I want you to think about someone for a second. A man named David, 54 years old, electrician. Spent 28 years building up a modest retirement account, some home equity, a small savings cushion. Not wealthy, but stable, proud of what he'd built. 2008 hit, he lost 40% of his retirement portfolio in 11 months. His home equity evaporated, and because he'd taken out a small business loan using his personal assets as collateral, he lost that too. David did nothing wrong. He just didn't know what he was allowed to do before the crisis. That's the part that haunts me about stories like his. The protection was available. The legal tools existed. He just never knew to reach for them. This video is about reaching for them, now while there's still time. Over the next few minutes, I'm going to walk you through 5 strategies that ordinary, non-wealthy people have used legally, without tax fraud, without shady offshore moves, to protect what they've built when the economy turns against them. Some of these will surprise you. One of them, honestly, most people assume is only for the ultra-rich. It's not. But before we get to strategy number 1, I need to show you something most financial advisors will never bring up in a client meeting. Because what's coming in the economy right now isn't just a cycle. It might be something bigger. There's a chart that's been circulating among institutional investors for the last 18 months. Not on mainstream financial news, not on the apps you use to check your portfolio. It shows the correlation between 3 specific economic indicators: consumer debt-to-income ratios, commercial real estate vacancy rates, and Federal Reserve liquidity injections, lining up in a pattern that has preceded every major U.S. financial crisis since 1971. Every single one. And right now, all 3 are flashing. Now here's where it gets uncomfortable. The people who track these indicators for a living, the institutional fund managers, the family offices, and sovereign wealth funds, they've already moved, quietly, without press releases. They've been rotating out of vulnerable assets, shoring up hard holdings, restructuring exposure, while most ordinary people are still waiting for permission to take this seriously. That gap between what sophisticated money is doing and what everyday people know to do, that gap is where financial devastation lives. But here's the thing, and this is important. The strategies these institutions use, most of them have civilian equivalents, legal, accessible, designed in some cases specifically for people who aren't wealthy. Strategy 1 starts there. Depending on your state, you may be sitting on a legal protection so powerful that creditors, even in bankruptcy, cannot touch it. It's called the Homestead Exemption, and most people have no idea how much coverage they actually have. Here's how it works. If a financial crisis triggers personal liability, a failed business, a medical catastrophe, a lawsuit, creditors can come after your assets, your savings, your car, your investments. But in states like Florida and Texas, your primary residence is untouchable, unlimited protection. A creditor cannot force the sale of your home regardless of how much you owe them. In other states, the exemption caps at $25,000, $75,000, sometimes $500,000. The range is enormous, and most people have never looked up what their state allows. Here's the micro-action. Search your state's homestead exemption limit tonight, not tomorrow, tonight. Because if you ever need it, the clock starts before the crisis, not after. Courts look at when protections were established. Last-minute moves get challenged. But the homestead exemption only protects one asset, your home. What about everything else? Your savings, your retirement accounts, your small business equity. That's where strategy 2 becomes critical, and honestly, it's the one that surprises people most. Because it involves a legal structure that most people associate with corporations and wealthy families, but it was actually designed with you in mind. There's a legal structure sitting in plain sight that could be the single most powerful thing standing between you and financial ruin. It's not complicated, it's not expensive to set up, and it's been used by millions of ordinary Americans to protect everything they've built. Most people walk right past it, because nobody told them it was for them. It's called a limited liability company, an LLC. And before you say, that's for businesses, stop, because that assumption might be the most expensive one you ever make. Here's the core concept. When you own assets personally, a rental property, a side business, even certain investments, those assets are directly exposed. If someone sues you, if a debt goes bad, if a judgment is filed against you, creditors can reach everything attached to your name. An LLC creates a legal wall between you and that exposure. You move an asset, say a rental property, into an LLC. Now that asset lives inside a separate legal entity. A creditor coming after you personally cannot automatically pierce that wall and take what's inside. It's called charging order protection, and in strong LLC states like Wyoming, Delaware, and Nevada, that protection is remarkably robust. Here's what makes this accessible. A basic single-member LLC can be formed for under $200 in most states. Annual maintenance fees are minimal, and the asset protection it provides is the same fundamental principle used by real estate developers worth hundreds of millions of dollars. Same tool, different scale. But here's where people go wrong, and this mistake can make the entire structure worthless. It's called piercing the corporate veil, and it happens when people set up an LLC but then treat it like it doesn't exist. They mix personal and business finances. They use the LLC account for personal expenses. They never hold formal records. When that happens, a judge can look at your LLC and say, this wasn't a real separate entity, it was a shell, and they can tear down that wall entirely. The protection isn't in the paperwork, it's in the behavior. Separate bank accounts, clean records, no commingling, ever. Do it right, and that wall holds. Do it wrong, and it was never there. Now, the LLC protects assets you put inside it. But what about the money you're actively building? The cash sitting in your savings account right now? The retirement contributions you're making every month? Because here's something that stops most people cold when they first hear it. Certain retirement accounts already have a level of federal protection built into them. Protection that most financial advisors never bring up in a standard planning conversation. And the difference between which account type you're using right now could be the difference between keeping your retirement savings and losing them entirely. Strategy 3 is about knowing that difference, and once you hear it, you'll never look at your retirement account the same way again. Most people assume all retirement accounts are created equal. Same protection, same safety, same rules. They're not even close. And the account type you're using right now, the one your HR department defaultly enrolled you in, the one you've been contributing to for years, may have a vulnerability you've never been warned about. Here's something buried inside a 1974 federal law that most people have never read. The Employee Retirement Income Security Act, ERISA, grants certain retirement accounts an extraordinary level of protection from creditors. We're talking unlimited protection. Federal law, almost impenetrable. 401ks, 403bs, pension plans sponsored by employers, these fall under ERISA's umbrella. In a bankruptcy filing, in a lawsuit, in a financial catastrophe, creditors generally cannot touch these accounts. The protection isn't capped, it doesn't expire, it exists specifically to prevent people from losing their retirement savings during financial hardship. But here's where it fractures. IRAs, individual retirement accounts, are not covered by ERISA. They fall under state law, and that protection varies wildly. Some states protect IRA assets fully. Others cap protection at $1 million. Some offer shockingly little coverage at all. So, if you left a job, rolled your 401k into a traditional IRA, which most financial advisors recommend as standard practice, you may have just moved your retirement savings from a federal fortress into a structure with far weaker walls. Not because you did anything wrong, because nobody told you this distinction existed. Think about what that means practically. You spend 20 years building a retirement account. You follow every conventional piece of advice, contribute consistently, roll it over when you change jobs, watch it grow. And then a financial crisis hits, a lawsuit follows, a business debt becomes personal, and suddenly the account you built your entire future around is exposed in ways you never anticipated. This isn't hypothetical. Bankruptcy attorneys see this scenario regularly. The paperwork is always the same. The devastation is always the same. The solution, though, once you know it, is simple. Before rolling any employer-sponsored plan into an IRA, talk to a fee-only financial advisor specifically about creditor protection in your state. In some cases, keeping assets in an employer plan or choosing a rollover structure that preserves maximum protection is dramatically safer than a standard IRA rollover. One conversation, potentially a lifetime of difference. Now, here's one that almost nobody outside of estate planning circles talks about. If you're married and you own property jointly with your spouse, there's a titling structure available in about half of U.S. states called tenancy by the entirety. Under this structure, jointly owned property cannot be seized to satisfy a debt belonging to only one spouse. Think about what that means. If you personally face a lawsuit, a business failure, a judgment, creditors cannot force the sale of property held under tenancy by the entirety to satisfy your individual debt. Both spouses would have to be liable for the creditor to reach it. It costs nothing to set up, beyond the legal paperwork to retitle the asset correctly. It requires being in a state that recognizes it, and it requires being married. But for the people it applies to, it's one of the most elegant and underused protections in American property law. 4 strategies in, each one powerful, each one legal, each one available to ordinary people right now. But here's what I haven't told you yet. All 4 of these strategies share a single critical weakness, a timing problem, a legal tripwire that can render every single one of them completely useless if you trigger it. And the worst part? Most people trigger it without knowing because they wait until the crisis is already visible before they act. Strategy 5 isn't just another protection tool, it's the strategy that makes all the others work. And it starts with understanding something called fraudulent conveyance and exactly how close most people unknowingly get to crossing that line.
Everything we've covered so far, the Homestead Exemption, the LLC wall, the ERISA fortress, the tenancy by the entirety shield, all of it can be legally dismantled in a courtroom. Not because the strategies are flawed, because of when you use them. This is the part nobody talks about, and it's the part that matters most. There's a legal doctrine called fraudulent conveyance, sometimes called fraudulent transfer. Here's what it means in plain language. If you move assets into an LLC, into your spouse's name, into a protected account structure, after a financial threat is already visible, a court can look at that transfer and say, you did this to dodge a creditor, and they can reverse it entirely. Everything you moved, clawed back, exposed. The legal system doesn't just look at what you did, it looks at when you did it and why. And here's the terrifying part about timing. The threat doesn't have to be a filed lawsuit for the clock to start. Courts have ruled that a foreseeable threat counts. A deteriorating business situation, a known dispute with a creditor, even an economic environment that made risk obvious. This is why people who scramble to protect assets during a crisis often end up worse than if they'd done nothing. They've created a paper trail that looks exactly like what fraudulent conveyance is designed to catch. The 5th strategy isn't a legal structure, it's a mindset shift that makes every other strategy work. Protect assets when you have no reason to. That sentence sounds almost too simple, but it's the principle that separates the people who come out of financial crises intact from the people who lose everything. When there's no lawsuit pending, no debt crisis looming, no visible economic threat on your personal horizon, that's precisely when asset protection moves are cleanest, strongest, and legally unassailable. Set up the LLC now. Review your retirement account structure now. Check your state's homestead exemption now. Retitle joint property under tenancy by the entirety now. Because when you do these things in calm water, they don't look like evasion, they look like what they are: responsible, legal financial planning. Courts respect that. Creditors can't easily challenge it, and the protection actually holds when you need it. Remember David, the electrician who lost everything in 2008? I want to tell you how his story ends, because it doesn't end where I left it. David spent 3 years rebuilding, and in that process, sitting across from a bankruptcy attorney, he learned every single strategy in this video. He learned them the hard way, after the damage was done. But here's what he told me that I've never forgotten. None of this was complicated. None of it was expensive. I just needed someone to tell me it existed before I needed it. He rebuilt. It took time. It took sacrifice. And today, his assets are structured, his property is protected, his retirement accounts are in the right vehicles, his LLC is properly maintained. The next crisis, whenever it comes, will not find him unprepared. And neither will it find you, not after today. Here's the reality we're living in right now. The economic indicators don't care about your timeline. The credit markets don't care about your retirement date. A financial crisis doesn't pause because you weren't ready. But the law, the same law that feels like it was written for wealthy people, actually built in protections for everyone. Homestead exemptions, LLC structures, ERISA coverage, property titling strategies, and the foundational principle that ties them all together. Act early, act clean, act now. You don't need to be rich to protect what you've built. You just need to know what you're allowed to do. And now you do. If this video changed how you think about your financial security, share it with someone who needs to hear it. Not tomorrow, today. Because the best time to build a fortress is always before the storm appears on the horizon. The second best time? Right now.